Good morning. Welcome to our webcast. We will be recording this session and sharing the replay link along with slides in a follow-up communication. We also encourage you to ask questions using the chat window. If your question is not answered during the presentation, we will follow up with you personally. Now I'm pleased to introduce you to David Seiden, our state and local tax practice leader. David?
Thank you, Andrew, and good morning. I'm David Seiden, a partner here at Citrin Cooperman, and I head up the state and local tax practice for the firm. With me today are my two state tax partners, Eugene Revere and Tommy Walsh. Yeah, that was me. So I downloaded an app this morning because I wanted another sound and I couldn't help myself. And the reason my two partners are here is because they, as you could tell, I get distracted easily, and they assured me that they were going to keep me on point, given that we promised to keep this to just 30 minutes. We have over 800 people participating in today's webinar, which in my humble opinion validates the importance of today's subject matter. So this morning, we're going to provide an overview of last week's landmark Supreme Court decision and hopefully help your business decide what, if any, actions need to be taken in both the short term and long term. Please understand, entire college courses are devoted to the constitutional issues raised in the Wayfair case. This webinar is not intended to debate, agree, or for that matter, disagree with the court's conclusions, but rather provide businesses with enough information to make good decisions on how to react to the new sales tax world we are apparently now in. In order to understand the Wayfair decision, there is one term you all need to understand, and that's nexus. In the state tax world, nexus refers to the minimum connection between a state and a business which lawfully allows the state to mandate such business collect and remit sales tax on taxable purchases made by in-state residents. Yes, that's a mouthful. Here's what the bottom line is. A state can't require your business to collect sales tax unless that business has a minimum connection with the state. The main issue addressed by the Supreme Court in Wayfair was how to define minimum connection. For the last 50 years, the minimum connection standard for sales tax nexus required a business to have a physical presence in a state like an employee, inventory, and/or an office before the state could require that business to collect and remit sales tax. And that's what everybody talks about, and we're going to talk about going forward, the physical presence standard that has historically been for sales tax collection. The last time the Supreme Court addressed this issue was back in 1992. In that case, it was called Quill, the court concluded the minimum connection standard was only met if the business had, quote, more than a de minimis amount of physical presence, unquote, in the state. And so the physical presence standard has stood for over 50 years, since the court first addressed this issue back in 1967. Funny things have happened over the last 25 years since the court ruled in Quill. Our economy has transformed from a brick and mortar economy to a major e-commerce economy. To emphasize the point, or this particular point, in the Wayfair opinion, the justices actually stated that in 1992, less than 2% of Americans had internet access when they ruled in Quill, while today that number is about 89%. In addition, the justices recognized that in 2015, Amazon overtook Walmart as the world's largest retailer. Finally, the last bullet on this page is obviously why the Wayfair case was being so closely watched by so many states. The existing physical presence requirement made it very difficult at best for states to collect sales tax from residents on in-state purchases. It's been estimated that annually the states lose over $20 billion in uncollected sales tax on internet purchases. That's a lot of money. Now, on a side note, it's estimated that South Dakota's share of the $20 billion in uncollected sales tax is about $50 million, which I'm sure is a lot of money for South Dakota, given it doesn't even have a personal income tax. Given the magnitude of the money at stake, over the last 2 years, South Dakota, along with about 20 other states, have enacted legislation that permits the state to mandate sales tax collection on businesses that meet certain business activity thresholds but not require any physical presence. For example, on the slide you see what South Dakota's law says, which is an out-of-state seller that either grosses annually more than $100,000 in state revenue or have over 200 separate in-state transactions are required to register, collect, remit, and file sales tax returns. And guess what? There's no mention of that in physical presence. It's important to note that while a lot of today's discussion involves e-commerce sellers, since that's obviously what Wayfair is, the court's ruling affects all businesses, regardless of whether the sales are done on the internet or not. For example, software companies, certain service companies, brick and mortar companies that ship things to various other states, all of these types of businesses are now going to be affected by the Wayfair decision. So that brings us to April of this year, when oral arguments were made before the Supreme Court. South Dakota, and for that matter, all its supporters had one goal: have the court overturn the 1992 court's Quill decision and rule that physical presence is no longer required in order to meet the minimum connection standard for sales tax. Here's my noise machine. One more second. I have to get my drum roll. Awesome. So last Thursday, the Supreme Court ruled in South Dakota versus Wayfair that one, South Dakota's sales tax law is valid, and that National Belahas and Quill's physical presence standard is overturned. While the court remanded the case back to South Dakota, I'm told this is merely a procedural matter, and that South Dakota sales tax law is now the new sales tax NEXUS standard across the United States. It appears the majority of the justices based their decision to overturn Quill on three things. First, South Dakota's law applies a safe harbor to businesses that transact limited business in the state. The safe harbor is that it doesn't apply to companies that have less than $100,000 of annual in-state sales or less than 200 separate transactions in a given year. Second, South Dakota's law will not be applied retroactively. The justices felt very strongly that any type of change in how they rule on a going forward basis should be done on a prospective basis. And lastly, South Dakota, along with about 20 other states, have adopted the streamlined sales tax agreement. Let me just quickly tell you what that means. Back in 2000, a group was created and tasked to try and simplify and create uniformity with respect to multi-state sales tax. The focus of the group was to look at state sales tax rates, administration of the sales tax among the states, create uniformity, definitions of taxable and non-taxable products and services, and create uniformity of sales tax sourcing rules. They put all of these recommendations together into the SSTA, and as I previously mentioned, there's about 23 states that have adopted this agreement, South Dakota being one of them. And there you have it. Physical presence is dead, no longer the law of the land with respect to sales tax. So, what should a business do now that Wayfair has been decided? Let's start by reviewing what we know. First, we know South Dakota's law is constitutional. Next, there's a new lower sales tax NEXUS threshold that no longer requires physical presence. Third, over 20 states have South Dakota-like sales tax statutes that are already been enacted into law. And finally, Only one state, North Dakota, is on record as stating they will begin enforcing the Wayfair decision immediately. Having said that, many of the states have enacted laws, like I mentioned, similar to South Dakota, and in those laws established January 1st, 2019 as the effective date. So a lot of things are going to be happening between now and then in guidance from the states. I don't know about you, but what's up with Dakota? I mean, we have the Dakota. So North Dakota is taking the lead in starting to implement it. South Dakota brought suit in this particular case. And oh, by the way, I'll give you one guess who brought suit back in 1992 in Quill, North Dakota. Okay, so what should your business do now? In my opinion, businesses have three options. First, you could panic and start to register in every state that imposes a sales tax. Second, do nothing and wait till the states catch up to you. Or lastly, conduct a Wayfair analysis, which I'll discuss in a moment. Please understand there are likely acceptable reasons any of the above three options make sense for a business, but there are some very costly pitfalls with respect to the first two options. While registering in all the states eliminates the risk of being held liable in the future for uncollected sales tax, the compliance cost of registering, collecting, and filing the likely hundreds of sales tax returns will be very expensive, to say the least, and it will take a full-time person to manage the barrage of notices the business will likely start receiving from the various states each month. So be careful if you decide to choose option one. I'm sure a lot of businesses will want to pick option two, which may or may not be a good strategy, but I need to point out a few things. First, sales tax is supposed to be a consumer tax unless a business was required to collect the sales tax and did not. At that point, the business is jointly liable with the customer for the unpaid sales tax. I generally tell clients that they have one chance to collect sales tax from customers when you bill them. After that, good luck trying to get the sales tax because likely you now own that sales tax liability. Two other things. If your business does not file sales tax returns, there's no tolling of the statute of limitations, which means, for example, if a state determines in the year 2025 your business had a sales tax collection responsibility as a result of the Wayfair decision starting in January 1st of 2019, your company could be assessed 6 years of uncollected sales tax, plus interest, plus potential penalties. Multiply that by the number of states your business opted not to file in, and yes, you get a very big, ugly number. Finally, as a reminder, sales tax is considered a fiduciary tax, which means individuals like owners, CFOs, treasurers, etc., can be held personally liable for any unpaid sales tax liabilities of the business, regardless of how the business is organized. So while I get it, the old ostrich in the sand approach may make it a lot easier to deal with this, in the long run, it might be a whole lot more expensive. So that leaves us with option three, a Wayfair analysis. Now, keep in mind, we've made up that term Wayfair analysis. It simply means applying the Wayfair decision against a company's specific facts to determine a course of action that company should take. No? The following are the specific steps to determine how a business should react to Wayfair. We've broken down this Wayfair analysis into two phases. In phase one, first, determine if the company has any historical sales tax exposure based on physical presence standards. So what we're going to try to do in phase one is we're going to get data points. So again, somebody can make the decision based on good data on where the company should register and start collecting and filing sales tax returns. And obviously the first point is did you have any historical exposure under the old rules? So that's first. Second, determine potential prospective sales tax collection responsibilities based on South Dakota's business activity threshold test. What does that mean? That means we know that the Supreme Court has said that if you have $100,000 or more in sales in a particular state, or over 200 transactions in a particular state, that's enough business activity to enable that state to require you to collect and remit sales tax. So let's identify which states that applies to your business. And then finally, prioritize the company's sales tax registrations based on the above, based on a number of weighted factors. Please keep in mind the following is not an all-inclusive list, and please note these factors are not equally weighted. It really depends upon a particular business, how they do it, and other factors. So what are these factors? A company's historical sales tax exposure. Number two, states where a company does business and whether such states have enacted a South Dakota-like sales tax statute. Three, is that state a member of the SSTA? Number four, are the company's products and services subject to sales tax in the state? Again, please note that the subjective part of the Wayfair analysis is to determine which factors are important based on the business and how to weight each of them. This is where an understanding of sales tax and experience comes in handy. Once a prioritization of the states is established, go to phase two, where a company needs to first evaluate its internal capabilities of complying with various state tax compliance laws. Next, determine the ability of the company's current accounting system to integrate a sales taxability matrix and updated sales tax rates. In other words, in each state where the company has a sales tax collection responsibility, a sales taxability decision needs to be made on every product and/or service sold by that company in that state, as well as determining the proper rate based on the billing address of the customer. Once that matrix is created, on a best case, a company can integrate that into their accounting system, so every invoice will automatically have sales tax charged on it if it meets the parameters of the matrix. A lot of companies currently do this manually, but with the increased likely compliance, it will become more and more difficult to do it this way. Next, the company needs to determine whether the sales tax compliance function will be done internally or outsourced. If internally, what software should the company use? There are a number of providers of sales tax software with a wide range of costs. Finally, a company needs to determine a cost-efficient way to register for sales tax in all its new states. Bottom line here, based on the results of everything we've just talked about, now a company can make an informed decision on how they should address the business, or actually the effect of Wayfair on its business. So that's a lot. There's a lot of stuff here that a company needs to focus on, and there are a lot of decisions that a company needs to make. Let me share with you some of my final thoughts on this as it relates to the Wayfair and what a business should do. First, and probably the most important thing you should take away from this morning's webinar, is to make sure you make an informed decision on how your business should react to Wayfair. Don't overreact, but don't underreact either. There are three options. You pick the one that best suits your company. Next, understand that the Wayfair decision has created as many questions as answers. For example, are South Dakota's business activity thresholds a floor? Meaning, if a company says that it's not $100,000 of in-state revenue, it's $50,000, does that make that state's law unconstitutional? In my opinion, the state just opined on what South Dakota's rules were. They did not create a floor, and what likely is going to happen, that issue, along with the next few, are going to be litigated in the courts for probably the next 25 years. So things like, what happens if a state is not a member of the SSTA? Does that invalidate their law? Can a state make sales tax law retroactive? Again, all of these things will likely take years to figure out through the courts. My final two closing thoughts are this. Likely, most states will at some point adopt sales tax standards similar to South Dakota, or possibly even more aggressive. Who knows? Maybe a state will take the position that a business has sales tax nexus by merely saying the state's name. Okay, I'm exaggerating, but you get the point. And finally, compliance with the new standards will be costly, whether the company decides to be in compliance or not in compliance and creating the exposure. So with that, I want to now turn to my partner, Eugene. Questions?
Yeah, we had a couple great questions, Dave. Let's try to go through a few of them, and we'll follow through with the participants if we don't get to all the questions. One question was a pretty straightforward one, but it deserves some attention. Someone asked whether it's essentially an and or test, right? So do you have to meet both standards, the $100,000 threshold and the 200 transaction threshold, or do you have to just meet one of them and thus get hit with a potential sales tax nexus?
So my understanding, and I have to go back and look at the South Dakota law, is that it's an or.
Yes.
And that, so again, what the court was ruling on was South Dakota's law.
Specific law.
Specific law. And their specific law clearly says either you meet the 100,000, greater than 100,000, or 200 transactions.
Right, and a state could theoretically come in and say, you know what, we want to go easy on small businesses. Let's make it an and test, say. And I think that would essentially raise the threshold that you have to meet both of the both of the tests. But I don't think anybody would go there, right? Because South Dakota, the Supreme Court kind of said, this is what's going on. We're ruling on South Dakota. Now every state can come in and say, okay, now we understand what's possible. We need to either follow South Dakota, set a threshold at $500,000. Some states have gone that way.
Right. So as I think we said earlier, is it? I don't think they created a floor. They just opined on South Dakota. States can obviously go higher, right, but the litigation to come will be the states that set it lower.
Exactly. Another person asked about, what is the measuring stick here? Is it, how do we figure out how much $100,000 is? Is it periodic? It's an annual test, right? You
Yes.
look back on your prior year, and I think that there's a twist to it, right? That you look at your current year you can look at your current year as well. So if you go back to 2017 and you have over $100,000 sales in South Dakota, then you hit the threshold. If you say you're in early 2019 and you look back on 2018 and it's $100,000, it's a forever moving stick. So, but it's an annual test.
Yes, and I will. I've been asked the question. Well, what happens? Do you have to go back and collect sales tax once you hit the threshold, or is it at that point? And it's my understanding is that at that point when you hit the threshold, you have NEXUS, and therefore the requirement to collect and remit sales tax. You did not have that requirement prior to that. So it's really on a prospective basis once you hit the thresholds.
Right. Another question that came in is, what happens if you register and then you find out that you did not hit the threshold? So say you didn't hit the $100,000 threshold. Are you going to have to refund the sales tax to the customers, which I don't think there's any possibility that there would be an expectation for that to happen. So I would say if you don't hit the threshold, and you look back and you collected the sales tax, remit the sales tax and then contemplate whether you should deregister. Right? It's a pretty straightforward response.
I think that's right. And just understand that registering and then pulling out of the state and then finding out, 8 months later that you have to register again, that is expensive to do, time-consuming to do. And my own opinion is that if you believe you're going to be in there, stay in there, even if you don't think maybe over the next 12 months you're going to meet the thresholds. Anything else? Okay. Let's do one more.
Okay.
And then we have 3 minutes.
So good question about non-U.S. entities and the impact on non-U.S. entities.
I just had this with a UK company.
Right. So, foreign company, no permanent establishment in the U.S. What does that mean for them? Okay. So, again, this is me speaking. Nothing's out there yet. So I have a UK entity that has created a cloud-based software for the financial services industry. And so up until last Thursday, there was no requirement for them to collect sales tax because they did not have any physical presence here in the United States. Well, guess what? Under effective last Thursday, that rules have all changed. Now, when they become effective is to be determined, but there's a perfect example of there will be a requirement if a company like this UK company meets the thresholds and SaaS is subject to sales tax, that they're going to have to collect sales tax from the vendor, register, even if they're not even if they don't have a permanent establishment in the United States. That's my understanding, and we'll see what happens. Yeah, well, we'll monitor it and wait for clarifications, but that's my understanding too.
Yeah. Okay, so, all right, first of all, I don't want any comments of the picture because my mother personally approved that picture. So we don't want to hurt Mom's feelings. Feel free to make fun of Eugene and Tom, though. Seriously, this is big stuff. I just started, I'd been in federal tax for 10 years in 1992, and when I transferred into state and local, and in 1992, there were 2 landmark state and local cases, Quill and Wrigley, that kind of changed the face of state taxes for 20 some odd years. We have another moment here like that in state and local, and this is a big deal. And I just want to emphasize that given it's a big deal, companies should focus on this, but not panic. And, make good, informed decisions based on the data that's available. And we went through a lot of the things that you ought to be looking at when making that decision. Obviously, we're always here, any of us that can help navigate you through that, or your other tax advisors. And again, I just want to thank everybody for joining us this morning. And if you have any other questions, we'll try to get back to the people that asked questions over the next 2 days that we didn't get a chance to address. But if you have any questions, feel free to reach out to us. Thanks, and have a great morning. Bye-bye.